I've shown all the evidences. I have also read out the paper book and the relevant portions. I have to cite the judgment for that. And thereafter, the written notes I will submit in course of the day.
During the
Course of the day, submit
during the course of the day.
Yes, sir.
You are for the appellate.
For the first thing, I will rely upon some of the law of Hiba, based on the law of Hiba as contained in the as contained in the book, and I will try to differentiate between the Hiba and the Hiba-bil-ewaz.
Hiba and Hiba-bil-ewaz.
One,
Learned counsel, could you use the microphone?
this is the which image. Firstly, what?
Provided a copy of the same.
This book, this book, no.
Copy of these pages.
No,
Not required.
I will take it from her.
Okay. Yes.
Firstly, for firstly, what is Hiba, It is a gift or transfer, of a determination of property without any exchange from a person to another, accepted by or on behalf of the latter. It is only a gift, and if your lordship see what are the capacities which are required for a person to be, donor must be a Mahabadan, a donor may be a male or a female, a donor may be married or unmarried, age of majority, a donor must be the age of majority, the ownership of the property must be his, free consent must be his, and the capacity of a Doni must be, he is also a Doni may be a Mohammedan or a non-Mohammedan. It is not required a sex. Doni may be a male or a female. A Doni may be married or unmarried. A Doni may be a major or minor. So majority or minority does not matters in case of a Hiba.
So in respect of Hiba, there is no
No
consideration required.
No consideration required. My lord, thereafter, my lord. If your lordship comes to page 6.
Yes.
Well, Hiba-bil is a peculiar concept of Muslim law. Hiba means gift and Ewaz means consideration of a return, or Hiba-bil is therefore a gift with an exchange or a gift for consideration. Under all systems of law, there cannot be any consideration or exchange in transaction of gift, but in Muslim law, it is applicable.
The main difference is gift with an exchange
or
a gift for consideration.
It becomes a sale.
This is the main difference between Hiba and Hiba-bil-ewaz.
Yes. But there are something more. The two essential conditions are necessary to render a transfer as Hiba-bil-ewaz. A valid and complete gift by donor to donee. It means three essential conditions of a valid Hiba that is there, my lord. And the donee must something to the donor after completion on the gift. If donor pays the consideration, the gift is Hiba-bil-ewaz. If the donor pays the gift, continues to be pure Hiba. In actual payment of consideration on part of the donee is necessary. Adequacy of the consideration is not the question. As long as the consideration bona fide, it is valid, no matter even if it is insufficient. It is important to mention that in transferring the property to the donor in return of a gift to be made. My lord, in my lord, thus my lord, after the consideration is paid, my lord, the Hiba bill it becomes irrevocable in nature, my lord. It cannot be revocable. It becomes in reality it is a sale, my lord. After the ewaz is complete. That what I am trying to say, my lord.
Hiba is revocable.
No, Hiba-bil-ewaz is revocable. Hiba is revocable, but Hiba-bil-ewaz becomes irrevocable after the consideration is paid. It becomes a sale thereafter. In reality, my lord. If your lordship comes to the next page, page 8.
Can you show that from which portion you are
Page 8,
mentioning that Hiba is revocable? Which portion do you
but
indicate?
revocable, there is no mention over here, my lord. Revocable. I am not on the point of revocability, my lord. I am on the point of that, my lord. After the consideration is paid, whether it is sufficient or insufficient, it becomes a sale.
So you are stressing upon the point that amount of consideration
Is
not a factor.
insufficient. Is not the requirement. Consideration is the requirement, and once
Whatever be the amount.
maybe whoever pays it, but it becomes whenever that is done, it becomes a sale. It is not revocable.
Whoever pays it means,
My lord, whether it is paid by the person or by someone else, my lord, it becomes
paid by
some other person.
You are intending to mean that whether it be paid by the donee or not.
Or by some other person, it becomes when it is accepted, the consideration is accepted.
It is complete.
It is complete. And it is not questionable. But if your lordship comes to page 8, my lord. A hiba is a transfer of some property or right by one person called donor to another called donee without any consideration, but a hiba-bil-ewaz is a hiba for consideration or in return of ewaz or something. In hiba-bil-ewaz there are two transactions. One is of hiba, the second is for return or ewaz, but in hiba there is only one transaction. Both these transactions together are known as hiba-bil-ewaz. In Indian, hiba-bil-ewaz in reality is a sale and has all the incidents of a sale.
Which point do you intend to stress upon?
My lord, I intend to stress upon that this is after, my lord, the mere technicalities cannot, my lord, disturb the transaction which has taken place after the ewaz has been paid.
Once the ewaz is accepted.
Yes, ma'am.
Learned counsel, can you recapitulate? That's because it has been heard about more than 2 months.
Yes.
Yes.
Only the
Possibly
month of November.
6
possibly
months.
6 months, more than 6 months.
More than 6 months. I have before
months have passed by.
vacation. Yes, before vacation I have I have completed, and there before that after.
Let her complete, I will.
Yes. But only the assistance as regards to recapitulation is required.
I will do it.
And in addition to that, both of you be kind enough to furnish the written notes.
They have already
filed.
I will base that. That will recapitulate to you also.
अपनी envelope Yes, written notes along with the citations I do.
Yes, my lord. They have already submitted. It's my turn.
Find that is not very long. Yeah.
Four and a half.
I will only read that.
Yes, correct. Class.
Yes, my lord. And these two judgments, my lord, and another, my lord, citation, my lord. I have, my lord. I've taken out it from the website, my lord. I will also cite that also. My lord, my lord, firstly, AIR 1991 Calcutta 405, and thereafter, my lord, 2001 to CLJ.
One by one.
Yes, my lord.
Which paragraph are you referring? From AIR 1991 Calcutta 405?
My lord, finding of fact, second appeal interference possible when finding is based on no evidence or non-consideration of proper evidence or omission to consider the entire evidence. My lord, para 8, my lord. My lord, head note, my lord, para 8.
Place the paragraph.
Yes, my lord. And thereafter, my lord, one.
No. Place the paragraph. All the above decisions tend to.
All the above decisions tends to emphasize the legal principle that a finding of fact by the lower appellate court, whether concurrent with the lower court or not, can be considered in suitable cases on second opinion if the finding is on no evidence or non-consideration of proper evidence or omission to consider the in all cases non-consideration would be a point of law within the scope of section 100 of the scope of the point admits different interpretation, and there have actually been divergent interpretation, but the ratio recently seems to be that in a second appeal, evidence and fact be repressed in suitable cases to prevent the miscarriage of justice. Only, my lord, in special cases, my lord, it has to be
Interfered with.
interfered with. And thereafter, my lord, also.
According to you, herein, such situation has not arisen.
No, my lord. And my lord, also, paragraph 14, 14 and 15 and 16, my lord. But I'm not reading it, my lord. In second, my lord, if your lordship comes to the head note, my lord, it says that, my lord, deed of gift, no specific denial of execution, document duly registered, examination even of attesting witness was not necessary as the court ruled, my lord, and title of plaintiff, eviction of title of plaintiff to the property proof, no proof of title of defendant presumed to be licensee liable to be effected, my lord. If the plaintiff proves his title and the execution of the deed is by a registered document, and even in that case, my lord, the attesting witnesses was also not examined. In my case also, in my case, the attesting witnesses were examined. They proved the case, and even the power of attorney holder told that he had knowledge of the same, my lord. And in that case also, my lord, and thereafter, my lord, the defense, the licensee cannot, my lord, challenge the title of the plaintiff, my lord, ownership of the plaintiff.
You are the subsequent owner.
No, real owner was
You had not implicated this person as a tenant.
firstly, my lord, the property belonged to my grandmother. Thereafter, by deed of gift,
It was handed over to you. It was given to you.
it was given to um, one of his daughter-in-law and to me. And thereafter, my lord, during the course of this second appeal, my lord, to my husband, during the course of this second appeal, my lord, my husband transferred this property by a deed of gift to me. I am presently, my lord, I am the wife. The plaintiff, the original plaintiff was my husband. And during this course, my lord, your lordship was pleased to allow that.
The appellants are challenging. The appellants are challenging the title of your husband.
Yes.
So you are referring to paragraphs.
Yes,
You are referring to paragraphs.
my lord, At 17 to 23, my lord. I'm not doubling by reading, my lord. So, এতদিন পরে আমার লেখাগুলো সব লিখেছি।
17 to 23.
Yes, ma'am. Yes, my lord. I am not placing it to traveling with your lordship. Well, nothing more, my lord. But in the above said, my lord, I
Second appeal need not be interfered with. Lord Counsel, in reply,
my lord, I will give the written notes in course of the day. কোনটা?
এই যে তুমি যেটা দেখালে 3 পয়েন্ট থাক The Lordship will take my written notes.
yes.
This is a suit for recovery of possession on revocation of license. Clear? He inducted me as a licensee and he asked me to vacate. I have not vacated. He filed a suit for evocation, eviction. Your Lordship will see the
original plaintiff.
Your Lordship see Sheikh Kurim is the owner. Asia Bibi, his widow. They have 2 sons, Sheikh Ansar Ali and Sheikh Shamsir Ali. Sheikh Shamsir Ali has 1 son, Sheikh Rajesh, who was the plaintiff. And Rajesh's wife is Phobi. For him, my learned friend is now arguing.
Presently, she is the plaintiff.
She is the appellant.
She is
The
respondent.
Respondent. And Sheikh Shamsir has a wife.
Substituted during the proceedings in the trial court or the first appellate court?
During this pendency of the appeal, second appeal, when my argument was over, at that point of time, he transferred in favor of his wife. And wife come with an application. That application was allowed by your Lordship.
Yes.
And Sheikh Ansar has 2 wives. First wife Samina and second wife Masina Khatun. That is, I am representing Masina Khatun. Here you also will find
you are the other son.
Other son's wife.
Other son's
Then
wife.
I'm reading. Originally, Sheikh Kurim, grandfather of Rajesh, the plaintiff was the owner of 9 decimals of land comprised in Dag number 474, as described in the property of the plain. He sold 2 decimal to the third party and gifted 7 decimal in favor of his wife, Asia Bibi, by a registered Hebanama dated 21st May 1982 and delivered possession of the same in her favor. Asia Bibi transferred 2 decimal land out of 7 decimal in favor of Sheikh Mohammad Rajesh, that is the plaintiff, by the registered Heba dated date your lordship mark 25th of 3rd of May 1984. That date your lordship mark, when the plaintiff was major, and 1 decimal in favor of Samina Bibi, the other wife of Ansar, by a registered Heba. Now this paragraph, this Asia again transferred some property. This line, paragraph you will see, Asia again transferred some property without description of specific area in favor of Sheikh Mohammed Rajesh, the plaintiff, who was described as minor, represented by his father, Sheikh Shamsher, upon accepting namaz from the father of the plaintiff by registered Hiba-bil-ewaz Exhibit 3. The plaintiff alleged that the alleged transferred 4 decimal in favor of by a registered Hiba-bil-ewaz dated 5th November 1986. When Hiba was done in 1984, then Rajesh was major. And Hiba-bil-ewaz in 86, Rajesh was described as minor. He alleged
When the second transfer took place,
5th November 1986.
5th November 1986. Therein, Rajesh has been stated to be minor, being represented by his father.
But in the earlier Hiba, in 84, Rajesh was major. He himself accepted the gift. Hiba. Actually, there is no dispute about that. Now the dispute, again, I am raising this dispute, that Exhibit 3, he is alleging that he got 4 decimal of land by Hiba-bil-ewaz. I have shown the Hiba-bil-ewaz to a lordship. No amount, no property was measured. No specific property was given. No area was described there.
What has been mentioned in the schedule?
No.
Something ought to be mentioned in the schedule.
That was our argument.
Document.
Your lordship, for the timing, take it. Either 1 decimal or 2 decimal, 3 decimal, 4 decimal, nothing has been mentioned. In this Exhibit 3, nothing has been mentioned how much area is transferring. Your lordship will not find.
Now, counsel, be kind enough to read out the top sheet. Exhibit 3 টা দিন।
So Mauja,
Typed copy has been furnished.
no. দেখুন অরিজিনাল ডিড একটা মার্ক করা ছিল, আমরা ফ্ল্যাগ করে দিয়েছিলাম এক্সিবিট 3টা। এক্সিবিট 3টা মানে এরকম ফ্ল্যাগ করা ছিল, এই যে ফ্ল্যাগগুলোর মধ্যে আছে এক্সিবিট 3। When your lordship got the original, then I am পড়ছিলে কোন জায়গাটা? সাত was না, এটা এইখানটা। Page 5 of that document, topsil was there.
Exhibit 1 is the power of attorney.
Yes.
Exhibit.
I will show Exhibit 1.
Who is the
What power has given?
What? Exhibit 3. Yes.
This is the
You
deed.
are referring to Exhibit 3.
3 now.
Be kind enough to place the top sheet.
Page 5. Topsil 1 and Topsil 2.
Yes.
We are concerned with Topsil 2. Mouja
Let the first one be placed.
first
Tafsil one.
tafsil is not for this property.
Let it be placed.
বাংলা লেখা হাতের লেখা
Now you are stating so.
থানা সাব রেজিস্ট্রি মৌজা ও জেলা বর্ধমান আমিন মৌজা বাহির সত্য মঙ্গলা জেল নম্বর 42 খতিয়ান নম্বর 1370 দাগ নম্বর 462 পুকুর নাকি এটা পুকুর প্রামাণ্য কি খসড়া গড়িয়ে হাগরা করিয়া হুজুর কি এক আনা এত শতক মধ্যে আমার নিজ অংশে এটা কত আনা শতক কমপ্লি 9 শতক মায়ের সজল মশাদি পাহাড় হয় কি করে ও পুকুর পাড় ও তাহার বিখ্যাতি সহ এই দিস ওয়াজ দ্য ফার্স্ট শিডিউল সেকেন্ড শিডিউল ওই মৌজা খতিয়ান নম্বর 1369 দাগ নম্বর 474 বাস্তু 1 আনা 16 আনা এটা 16 আনা 9 শতক মধ্যে 7 শতক তন্মধ্যে নূরজাহানের বাটির দক্ষিণ ময়না বিবির উত্তর সোমচের অন্ধ্রদাগের পূর্ব খাগড়া পুষ্করিণীর পশ্চিম গৃহাদি এটা কি সরঞ্জাম স্থাবর অস্থাবর সম্পত্তি 3 সহ দিলাম within 7 decimals he has transferred something. How much she has transferred by this deed, that was not mentioned here. And when your lordship is now I am coming to my notes.
Yes, Lord Counsel, we will continue.
No, I am also facing same problem which your lordship was facing. This week,
these pages are old pages and
no, not old pages, the cough and cold.
Aggravation is being created by these old pages also.
Dust allergy. The plaintiff, after revocation of license, filed the present suit. Original plaint was in respect of 7 decimals land, but amended plaint was in respect of 6 decimal of land. The defendant constituted a suit by filing written statement stating incident suit is barred by limitation and the alleged Hiba-bil-ewaz was manufactured collusive, fraudulent document and a paper transaction. The defendant denied the grant of license and stated that she is residing in the suit property as a family member of Asya Bibi, and on her death, she inherited the suit property as a co-sharer. Relevant evidence and documents filed in court. Plaintiff has not deposed in the suit. His constituted attorney deposed as PW1. Power of attorney was marked Exhibit 1. Hiba-bil-ewaz dated 5th November 86 was marked Exhibit 3. Hiba dated 23rd May 1984 was marked Exhibit H. Defendant was examined and documents relating to payment of electricity bills and Panchayat tax receipts were exhibited as C series to E series to show that she is residing in the suit property long before 1996, that is alleged granting of license, and that those documents starts from the year 1999 onwards after the death of Asya Bibi. But we have showed that I am the family member. After death of Asiya Bibi, I paid this electricity bill and all this tax. Their case is he got in 86. They said they have inducted her in 2006. Now, finding of the appellate court accepted the evidence of PW1 and held that the defendant has failed to prove that Hiba-bil-ewaz is a manufactured or collusive document. Relevant portion finding of the first appellate court at page 24 of the paper book is quoted below. It is pertinent to say that.
Learned counsel, where from can you prove that you have been gifted with the property?
Gifted with the property.
Where from?
Right from the from those two deeds, my lord.
Place one by one.
Deeds. Lord,
Do you have with them?
no, my lord, not ready with them, my lord. All those documents are not ready with me. Well, let him finish, my lord. If your lordship has any queries, I will complete in the next.
First appellate court said I could not prove by proper evidence that this is manufactured.
One thing I can apprehend that the handwritings will create some difficulty.
Yes.
For preventive measure, I want to have the typed copy of those documents. Can those be provided?
That can be done. That can be done.
Can be
Can
done.
be done.
These two deeds, Exhibit H and Exhibit 3,
That can be done.
84 and 86, two
Be kind
deeds.
enough to provide the typed copy of those documents.
That can be done. It will take some time, but not
Yes.
কত sometime লাগে? এক সপ্তাহ হয়ে যাবে। Now, appeal court said I could not prove that is a manufactured. This burden is shifted to me. Then what is my submission? What submission I made? Page 4. First point I've taken, the plaintiff has not proved that he acquired 4 decimal of land in Dag number 474 by Hiba-bil-ewaz Exhibit 3 for the following reason. Hiba-bil-ewaz is silent about the area of land transferred by the deed. This is my first argument was there.
So that is the moot point.
First. Second thing, Hiba was taken from the donee. Was taken not from the donee of the deed. It is stated that the Hiba stated that ewaz was taken from Samsed. She is submitting, anybody can take. He has said the 3 conditions, here donee has to give the ewaz. Page 7.
1 minute, 1 minute, 1 minute. Essentials of Hiba-bil-ewaz.
Yes, the following 2 conditions are necessary to render a transfer as Hiba-bil-ewaz. A valid and complete gift by the donor to the donee. It means 3 essentials condition for a valid Hiba is essentials, namely the declaration, acceptance, and delivery of possession. Every Hiba-bil-ewaz is pure gift in its inception. But as soon as the donee also makes a gift, donee also makes a gift. In return of the original gift becomes Hiba-bil-ewaz. Here says donee also makes the gift. Second, the donee must make something to the donor about the completion of the gift.
Where from have you got
Well,
this?
I have
word?
taken it from the internet one.
The donee must make something.
Well, I have taken it.
Only have to do this. There may be typing mistake. Nowhere these 3 grounds anybody else can give the ewaz. Donee has to give the ewaz after accepting the deed. Hiba. Here, Dhoni has not paid anything. No years has been paid by the Dhoni.
Second part of the second line. Second part.
The Dhoni must make something to the donor after the completion of the gift. If the Dhoni pays the consideration, the gift is Hiba-bil-ewaz. If the Dhoni does not pay, the gift continues to be a pure Hiba. Then it is not Hiba-bil-ewaz. Actual payment by consideration on the part of the Dhoni is necessary. Adequate consideration is no question. As long as the consideration is bona fide, it is valid, no matter whether it is insufficient. It is important here that the Dhoni must mention it clearly that he is transferring property to donor. Dhoni has transferring the property to donor.
There is also nowhere it is mentioned that on behalf of the Dhoni, anybody
Yes,
else can pay.
Yes, my lord. But in that gift, in the deed itself, my lord, it was represented that the Dhoni was a minor at that time.
So-
But we can't go in back to that situation. What was there, my lord? But my lord, if his father
Being the minor,
his father paid
his father was representing him,
and he
as such,
paid
his
it.
father has paid.
Paid it.
We
Yes,
were
my lord.
relying on that point.
That point.
That's it.
Now, now this C, third point. Dhoni was described as minor in the Hiba-bil-ewaz, executed on 5th of November 1986. But in the Hiba dated 23rd of May 1984, the Dhoni was described as major. If this is correct,
How can that be at a later stage? He becomes minor.
minor. If
After,
Hiba-bil-ewaz is accepted, then this Hiba is gone. Two things cannot be done. Either the Hiba is false, he was minor, he cannot accept that. But it is said in 1984 he was major. Now the fourth point.
whether there was any endorsement in the Hiba of 1984, endorsement of that person.
Acceptance এর কথা
Dhoni?
বলছি। এটা কি 84 না বলছো? 84 টা বলছো।
84 in the 1984 deed.
আসলে তখনকার লাগতো না, এখনকার লাগে। তখন অ্যাকসেপ্টেন্স হতো না। There, at that time, in the deed, they are always not necessary to accept in the deed itself.
Gift requires acceptance.
We require acceptance, but in the deed itself, it is not required. But at the present time, whenever a deed is executed, they take acceptance from the deed itself. Previously, any time, by any way, during the lifetime of the donor, Dhoni has to accept by any means. Now the fourth point.
After the coming into effect of the Transfer of Property Act, one has to accept the gift.
One has to accept. Dhoni has to accept, not at the same time, but during the lifetime of the donor. That was the law. Donor, an old Muslim illiterate woman, executed the alleged Hiba-bil-ewaz. The onus is upon the plaintiff to prove by cogent evidence that the donor executed the deed with full understanding about the contents and meaning of the deed. I have relied on judgment of 1963 Supreme Court 1203. After reading this page, I am saying what is there. Dhoni has not deposed in court. Dhoni is saying, I inducted you as a licensee in 2006. But he is not coming before the court to depose. His constituted attorney has not even authorized to depose in the suit. If your lordship sees the exhibit 1, he has not given the power to depose.
The constituted attorney.
Constituted attorney. Here, constituted attorney deposed. Now,
He has been cross-examined.
I am coming. Plaintiff has not deposed.
He has been cross-examined.
Yes.
Was that question raised at the time of cross-examination?
If it is what he can say, what is his personal knowledge he can say.
No. The point which you are raising now, was that raised at the time of cross-examination of the
This
witness?
is a pure question of law I am saying. I will next point number 2, then I'll explaining. Plaintiff has not deposed. Constitutional attorney has no authority to depose on behalf of the donee. Therefore, the grant of license was not proved. More so, the grant of license from 2006 is proved to be false in view of the evidence of the defendant that she is residing in the suit property since her marriage and paying taxes and other payments since 1999, after the death of Asia Bibi. I have relied on a decision of Supreme Court in 2010. There it is said the power of attorney holder cannot depose. His evidence cannot be looked into.
If he has not been authorized to depose.
Not only what can the power of attorney holder depose, which is his knowledge,
Which is within
which
his
he
knowledge.
acts,
Hmm.
which is not his knowledge, he cannot depose to that. But these two judgments, my lord, I have the next and I have to rely. Lord, either my lord will take, I will conclude the judgments. The lordship asked him to ask her some questions.
Yes.
That was to place those smaller deeds smaller. The deeds smaller title is I will annex. I'll prepare my lord type copy and I'll give it to your lordship.
The typed copy be furnished, and prior to furnishing, let a copy of that typed
Type
copy
copy. Yes.
be handed over to your adversary. Yes.
In 2010, Supreme Court said, I'm just not explaining where a
Which you have referred. 2010 SCC
yes,
512. Yes.
paragraph 14, where a party to the suit does not appear in the witness box and state his own case on oath and does not offer himself to be cross-examined by the donor other side, a presumption will arise that the case set up by him is not correct. Paragraph 15. Order 3, Rule 1 and 2 CPC empowers the holder of the power of attorney to act on behalf of the principal. In our view, the word acts employed in Order 3, Rule 1 and 2 CPC confines only to in respect of acts done by the power of attorney holder in exercise of the power granted by the instrument. The term acts would not include deposing in place and instead of the principal. In other words, if the power of attorney holder renders some acts in pursuance of power of attorney, he may depose for the principal in respect of such acts, but he cannot depose for the principal for the acts done by the principal and not by him. Similarly, he cannot depose for the principal in respect of the matter of which only the principal can have a personal knowledge and in respect of which the principal is entitled to be cross-examined. And the 63 Supreme Court, the burden, here the point was said, if a Pardanashin woman is executed document, then he has to prove that the Pardanashin lady has independent
burden shifts upon the donee.
Their Supreme Court has gone so far, even if you have said and so that deed was read over and explained to her, that will also not do. You have to prove by other evidence that she could have personal shared knowledge, perfect knowledge.
There is the relevant paragraph.
Paragraph 5. Paragraph 5. Your Lordship, kindly come to last.
It is settled law.
No, yes, last line, last sentence, Your Lordship will come. In India, Pardanashin ladies, have you Lordship got it? 4 lines from the bottom.
From the bottom of the paragraph.
Page, yes, paragraph 5. That page. That is page. I've given you.
Yes. In India, Pardanashin.
In India.
Let us go through the entire paragraph.
That I can.
No. The entire paragraph.
Entire paragraph. It is settled law that a High Court had no jurisdiction to entertain a second appeal on the ground of erroneous finding of fact. In the instant case, the learned Munsif and on appeal, the learned subordinate judge found concurrently that the two widows put their thumb marks without understanding the true import of the document. Imam J, in second appeal, reversed the said finding on the ground that they were vitiated by an erroneous view of the law in the matter of burden of proof. The judgment, if we may say so, with respect, consists of propositions which appear to be contradictory. The learned judge, after reviewing the case law on the subject, concludes his discussion by holding that it was the duty of the plaintiff to prove that there was fraud committed and that as that had not been established, the question whether the document was read over and explained to the plaintiff, in his opinion, in the circumstances did not arise. This proposition, in our view, is clearly wrong and is contrary to the principles laid down by the Privy Council in a series of decisions. In India, Pardanashin ladies have been given a special protection in view of the social conditions of the times. They are presumed to be an imperfect knowledge of the world. By the Parda system, they are practically excluded from the social intercourse and communication with the outside world. In Farid versus Usnisha, Lord Shamar traces the origin of the custom and states the principle on which the presumption is based. The learned judge observed, I am skipping it over. It is therefore manifest that the rule evolved. The protection of Pardanashin ladies shall not be confused with other doctrines such as fraud, duress, or actual undue influence, which apply to all persons, whether they are Pardanashin ladies or not. Now this paragraph 6. The next question is, what is the scope and extent of the protection? In Giresh Chandra's case, the Privy Council held that as regards the documents taken from a Pardanashin woman, the court has to ascertain that the party executing them has been a free agent and duly informed what she was about. The reason for the rule is that the ordinary presumption that a person understands the document to which he has affixed his name does not apply in the case of a Pardanashin woman. In Kali Box versus such and such, the Privy Council defined the scope of the burden of a person who seeks to sustain a, this is that quote. Next, now the view be broadly expressed through though affirmed in essence of subsequent decisions, was modified to some extent in such and such case. The mere declaration by the settler subsequently made that she has not understood what she was doing obviously is not in itself conclusive. It must be a question whether, having regard to the proved personality of the settler, the nature of the settlement, the circumstances under which it was executed, and the whole history of the parties, it is reasonably established that the deed executed was the free and intelligent act of the settler or not. If the answer in the affirmative, those relying on the deed have discharged the onus which rests upon themselves. Therefore, it had to be proved that it is an intelligent act. While affirming the principle that the burden is upon the person who seeks to sustain a document executed by a Pardanashin lady, that she executed it with a true understanding mind, it has been held that the proof of the fact that it has been explained to her is not only the mode of discharging the said burden, but the fact whether she voluntarily executed the document or not, could be ascertained from other evidence and circumstances in the case. The same view was again reiterated in the Judicial Committee through Dr. Sir George Rankin in Jagadish Chandra. Further citation is unnecessary. The legal position has been very well settled. Shortly, it may be stated thus: the burden of proof shall always rest upon the person who seeks to sustain a transaction entered into with a Pardanashin lady to establish that the said document was executed by her after clearly understanding the nature of the transaction. It should be established that it was not only her physical act, but also her mental act. The burden can be discharged not only by proving that the document was explained to her and she understood it, but also by other evidence, direct and circumstantial. Here nothing has been proved. Court said, I cannot prove. This is manufactured.
This was an issue before the trial court.
This was, that's not big, because this was our defense.
No, now it is your defense.
Yes.
At that relevant point of time.
Page 5 of the paper book are the issues, my lord.
Page 5.
Yes.
The issues are general issues.
General issues. But court has discussed it. Your lordship knows the framing of issue is for the parties to understand what is going on before in the trial. Had the court discussed it? But court said, this is burden on you, you have not able to discharge. ডকুমেন্টটা তুমি করবে তো ডিটগুলো না তোমার ডিট নাই
এইচটা নেই
এইটা নিয়ে ওকে স্কুলের কাছে নিয়ে নাও তোমার বান্ধবী ও ডায়েরি দিয়ে দেবে
আমাদের তো এইচটা নেই
এই দিয়ে দিও তো ওকে এক্সিবিট এইচ
my lord, I have only exhibit 3, but that exhibit H, my lord, that
দিয়ে দেবো জজকে সব বলতে হবে দিয়ে দেবে শিলারা
Cooperation is required.
yes, my lord, that I will take.
they are two good friends
But as regards to profession,
Yes.
no for the clients they will argue whatever to them
that
but
should be. That should be.
they can
We are sitting in the same room.
Same room. We sit in the same room.
So it is expected that it will be handed over
As fast as I can, my lord, within next week, my lord.
within 14th,
I think I may be. I
14th or 17th.
Your lordship is
And
sleeping.
as regards to the written notes of argument,
Written notes of argument I have prepared, my lord. I have to check it once, and I will. If you lordship is skipping it at 14th, I will give both the deeds and the written notes on 14th after giving them a copy.
will be better. 14th. For what purpose?
জসে বুঝবে কিনা তাই তো ঠিক নাই সেদিনকে
That is the question.
ওইটা প্রবলেম তো ওইখানেই
For what purpose?
let is be
My lord, one thing can be done. It can be handed over to your lordship's court officers, my lord, by giving
Better to hand over the typed copy and the
written note.
during the course of the day, if you can provide the written notes
Written
of
note I
argument,
can.
this bench is available.
And my lord, that if I can't, I will hand over both to the lordship's court officer.
Court officer, and prior to that, hand over a copy to your adversary.
ফ্রি আছে তো পরে বলবে না 3 নাই।
Heard the learned counsel representing the respondent uh, after conclusion of the submission, the learned counsel representing the appellant also concludes his reply reserved for judgment. এটা যে ট্রায়াল কোর্টের রেকর্ডটা
আমারটা লিখে
কেউ না can be used from
Oh, my lord, my application for addition of party, your lordship's last occasion partly heard me. And the last Friday when your lordship,
they were being represented. The
the
Appellants
respondent was
and the-
appeared because she was seriously opposing my application.
who
But
was-
the appellant,
she had appeared on the last occasion.
yes,
Who was opposing
my application,
your application?
yes,
But the appellants are not opposing.
is not. But may I come back 2 minutes? I shall inform her over phone. Or can I take it up at 2 minutes? I beseech your lordship, kindly take it up too, because I don't know whether I will get further chance.
Why not? You will get the opportunity.
So then, my lord, then my lord, break it not today, I shall some notice upon the respondent as well as the appellant, both.
No. None is representing.
I will can for.
None is. হ্যাঁ item number 2 তে না কোন ছিল কি হ্যাঁ এখানে লিস্টে নেই
Application now. Can for old number হচ্ছে 1827 of Puri.
3 months আছে
Can wives can for dispose of the আছে
না না মানে কাইন্ডলি এই অর্ডারটা দেখুন না 13 আগস্ট 2024 13 আগস্ট 2024
তার এর পুলিশ
6 নম্বর 7 নম্বর প্যারাগ্রাফ
business has not been disposed.
ক্লারিফিকেশন আছে মনে হচ্ছে
সেটাই তো করা যায়
After going through the orders, it transpires that the said application being CAN 4 of 2020, old CAN number 1827 of 2020 has not been disposed of. In such circumstance, let the said application being appear in the list along with the appeal after 1 week. It has not been disposed of.
It's pending, my lord.
Pending.
রেকর্ডে নেই রেকর্ড ও লিস্টে লেখা নেই হ্যাঁ রেকর্ডে আছে কারণ দর্শক একদিন হিয়ারিং এর সময় এটা দেখেছিল
ওল্ড নাম্বার যখন লিখে লিখতে 1827 হ্যাঁ 1827 so let the matter be not today.
not today মানে I will sub notice on the other side
এখানে ক্যানটা দিয়ে দেবেন ক্যান 4 of 2020
20 মানে
20
20 but I will sub come back নাম দিচ্ছি না দাঁড়া নাম দিচ্ছি
Pre-Lordship, I am for the appellant. Mr. Gopal Chandra Ghosh is appearing for the respondent. He is left for his submissions. We have completed our pleadings.
So on behalf of the appellant is that it has been concluded.
Lordship. Let it be passed over, Lordship, then.
Passed over. Inform Mr. Ghosh that the matter will be taken up.
My lord, answer the respondent. It is my turn to such arguments in the matter. In the last occasion,
Who is representing the appellant?
I am not sure who is representing my lord, but apparently they're on their way.
On the way.
That's what the clerk is telling me. My lord, can it be taken up at 2, my lord? That way that we can take the
What about the remaining 6 minutes?
6 minutes. I will barely be able to start in the 6 minutes.
Let the field be prepared for the
I don't know who I am for the appellant. I led by Mr. Ghoshal.
you have concluded.
Mr. Ghoshal, my lord, argued
Ghoshal has concluded.
Yes, my lord.
Let them start today. You will get the opportunity to give reply.
Yes, my lord.
And in the meantime, you prepare the written notes of argument.
My lord,
All are being requested to prepare the written notes of argument because there is a gap between the hearings.
yes, my lord.
Yes.
My lord, this case is of a very complicated history. There are multiple litigations which have been filed between the defendants and either the appellants or the predecessor interest of the appellants. And as a result, the matter has been complicated a fair bit. My lord, kindly sees the paper, kindly takes the paper book, my lord.
Yes.
This present second appeal is directed against a judgment and decree. Judgment and decree dated 24/8/2020, passed by the learned 11th ADJ of South 24 Parganas at Alipur in title appeal number 5 of 2020 arising out of title to suit number 20 of 2017. My lord, kindly sees the judgment and decree first passed by the learned second civil judge senior division, against which the first appeal was preferred.
You are referring to the trial suit.
Yes, my lord.
Suit.
Trial court's judgment and decree. My lord, I am read by Mr. Softanshu. My lord, kindly sees from page 16 is the judgment and decree of the trial court. So this was a suit for recovery of khas possession filed by the present appellant against the respondents. As kindly sees the judgments, as per the last amended plaint, case of the plaintiff is that the suit property comprises of two schedules. Schedule A comprises piece and parcel of 3 katas of land with structure at premises number 5/2 Rifle Range Road, Police Station Koraya, and Schedule B comprises the piece and parcel of 1 tile shed room having brick wall on the roof of ground 10th floor tenanted room and of the tenants Ashok Das and Pradeep Dushya at premises number 5/2 Rifle Range Road, Police Station Koraya. Plaintiff's specific case is that she became the owner of the Schedule A property by purchase and he is in possession.
Standing upon Schedule A.
Yes, my lord. Schedule A is the structure at
Disputed is Schedule B. They are only Schedule B measuring about 450 square feet.
Schedule B is the 1 tile shed room.
Yes.
Having brick built wall on the roof of ground floor. So on the first floor.
Only one room.
On the first floor.
Yes, madam. There is only one tile structure. In the tile structure, only one room. That is the dispute.
Dispute is in regard to only one room.
Only one room.
Not gone through.
Not all through.
May I express my difficulty? Normally, I don't accept change brief. At their request, I have accepted. Problem is, whatever has been done by Mr. Mondal's client for appellant, I am totally in dark. That's why, if the Mr. Mondal can formulate the point today, so I can
only
answer.
Point is formulated.
We are not there. That's a request.
Substantial question of law.
So that is my code.
My
The
only-
argument is there.
Only
Then this is only point is
point-
judicata.
First point is, my lord, admission.
Mr. Basu wants to have the moot point which you
argue
banking upon.
Yes, sir.
That
Nothing else. Res judicata I have seen the formulation of the court. Apart from res judicata, have you any other point argued before the court? You can argue. There is no bar.
Only, my lord, former suit is 24/19/97.
We shall take up at 2 p.m.
Yeah, my lord justice, they will not spare me.
He will continue. He will continue.
Only thing, my lord, required, I cannot assist your lordship unless the point raised by my defendant is known to me. So far as the formulation by the court, I know that. That is on writing. Question of res
Res
judicata.
judicata.
But apart from that, he has argued anything else.
Only res judicata. Res
He has
judicata by-
banked upon only the point of res judicata. Apart
Nothing
from
else.
that, nothing else.
Then, my lord,
Admission.
Let him continue. Thereafter, only your final touch is required.
then, my lord, can it be give the chance of next week?
Let us continue.
Very well. Let him continue on
Yes.
facts. So far as that part is concerned,
As regards to conclusion.
Yes. I have read so far as the res judicata part is concerned, I am ready. But I am inquiring, well, this is, I should not inquire. I should not accept the brief.
No.
Like this.
No. Okay. Let him continue. Thereafter, you will get the opportunity to
Supplement. So somebody left out, I should submit.
the kind leave, my lord. Item number 19, my lord. It's running. It's the matter, my lord, already, my lord, written notes of arguments has been given by us.
Direct counsel, each and every matter will be taken up.
Yes, my lord, the difficulty is that, my lord, will kindly remember this. Mr. Aniruddha Chatterjee has argued in this matter is the eviction of licensee, my lord. That, my lord, caretaker matter. Mr. Bhagat is appearing for the opposite respondent, my lord. Well, everything has been, my lord. We have submitted, we have given a written notes, my lord.
When the matter will be taken up, you submit.
The only problem is real sufferance at our part, my lord. Serious sufferance. Otherwise, I would have not disturbed your lordship. I would have not disturbed your lordship.
Direct counsel, everybody has the urgency.
Yes. Well,
Everybody has the urgency. That's why
yes, yes, my lord.
the part heard matters have been
Yes, yes, yes.
listed above.
Well,
all
only
the,
I am
all the
praying,
other
well,
matters.
Mr. Aniruddha Chatterjee has, well, if your lordship can, well, fix a specific, well, date or time, well, any time, well, it will take more, not more than 5 minutes. That is the
How can
problem.
that be?
Well, because one of the problem is that, well, Mr. Bhagat has also probably submitted everything. So, well, once you
Probably today and Monday.
very well. Then Monday lordship, well, takes it on, well,
Today-
Monday. Some preference, well.
Today this bench is available.
Yes, yes.
But
Today,
Monday
well,
is not available. Then can you allow me on Monday? I will confirm.
that is
Subject to.
Ballot, kindly take ballot. Let's proceed. Kindly takes the paper book. Lord, I was going on the trial court's judgment. Kindly sees from page 19, the issues are framed in the suit, in the trial court.
Yes.
Page 19. After considering the pleadings of both the parties, the issues were framed. Is the suit maintainable? Has the plaintiff's cause of action to file the suit? Is the claim of the plaintiff barred by limitation? Is the suit barred by estoppel? Whether the plaintiff is entitled to the decree as paid for? To what other relief or reliefs are the plaintiffs entitled to? But I'm skipping over the evidence part of it. Kindly sees page 21, bottom, the decision with reasons, which starts at page 22. For the sake of brevity and convenience and to avoid the repetition of facts, I am taking up all the issues together with discussion. Before this court, there are three vital documents which needs to be scanned very carefully. And after careful scanning, it appears that Title Suit 17 of 2009 was filed by Anand Mohan and others against Bulbuli Das and others. The suit was filed by Anand Mohan and others for declaration that the ex parte decree passed in TS 24 of 1999 was obtained by fraud and is not binding upon them.
That will be 1997.
1997. It should read 1997. Was obtained by fraud and is not binding upon them. After contested hearing, learned court took the view that in TS 24 of, again, 1997, it should be, decree of injunction was passed against Debashish Ghosh, who has no right, title, and interest over the property. And if the said decree is declared to be not binding upon the plaintiffs, then that will give premium to Debashish Ghosh, who tried to dispose Bulbuli Das and others who are admittedly in possession of the property, and accordingly he dismissed the suit. The judgment and decree passed in this suit is under challenge in TA 205 of 2010, and accordingly no conclusion can be reached in respect to that suit since appeal is a continuation of the suit.
Title Appeal 205 has been dismissed on the ground of res judicata.
Yes, my lord. TS 8 of 2005 was filed by Tarak Das and others against Anand Mohan and others. Suit was filed for declaration and partition. There the plaintiff prayed for preliminary decree of 1/12 share in the property. Here the defendants filed a written statement along with a counterclaim, thereby claiming recovery of khas possession of the room in occupation of plaintiff number 5 in that suit. After contested hearing, the suit was dismissed, holding that the plaintiffs failed to prove their title over the suit property. Counterclaim was also dismissed on the ground the person whose eviction was sought for died during the pendency of the suit, but the defendants had not taken proper steps in that respect. This judgment on decree is also under challenge in the appeal preferred by the plaintiff of that suit, who are the defendants in the suit before me. Sale deed being so and so. Here the vendor is Anand Mohan and the purchaser is the present plaintiff. The vendor traced his title, stating that Musammad Anwar Jan Bibi was the owner of the premises number 5/2 Rifle Range Road, who sold the property to Jogmaya Dasi and Fulbasia Dasi by registered deed of sale being number 1458 of 2038. Thereafter, Fulbasia Dasi died intestate on 5/12/1949, leaving behind her only daughter Jogmaya. Later, Jogmaya died intestate on 31/10/1979, leaving behind his only grandson Anand Mohan. This is purely based on the recitals of the deed. the tracing of title in the recitals of the deed. In the written statement as well as in the written argument, the defendant harped on the point the suit is barred by res judicata and constructive res judicata. Constructive res judicata is an artificial form of res judicata which provides that if the plea would have been taken by a party in the previous proceeding between him and his opponent, he should not be permitted to take that plea against the same party in a subsequent proceeding with reference to the same subject matter. To constitute a matter for falling under res judicata, certain conditions are to be fulfilled, which are the matter directly and substantially in issue in the subsequent suit, or the issue must be sought same matter which was directly and substantially in issue either actually or constructively in the former suit. Former suit must have been a suit between the same parties or between the parties under whom they or any of they claim. Such parties must have been litigating in the same title at this former suit. The court was decided the former suit must be a court competent to try the subsequent suit of the suit in which such issue is subsequently raised. Matter directly and substantially in issue in subsequent suit must have been heard and finally decided by the court in the former suit. It is well settled law that in order that the matter will be said to have been heard and finally decided, the decision in the former suit must have been on merit. And if the suit is dismissed and or decided on the technical ground, decision will not operate as res judicata in the subsequent suit since the decision was not on merit. As I have discussed earlier, none of the previous suits have reached the finality since appeal is pending against the judgment and decree is passed in the previous two suits. From the judgment of TS 8 of 2005, it is clear that the counterclaim was dismissed on the technical ground and not on merit, for which in my considered view, that will not operate as res judicata in this suit. I found nothing on record to hold that the suit is barred by constructive res judicata. In the written statement as well as in the written argument, defendants have pointed out that the sale deed of the plaintiffs is void and not binding upon them. Defendants admitted the ownership of Jogmaya and Fulbasia but denied the inheritance by Anand Mohan. They claim themselves to be the owner of the suit property by inheritance, but surprisingly, there is no clear line of inheritance shown by the defendants either in the written statement or in the evidence. In cross-examination, DW1 stated that they are claiming title to Sagar Kumar Das and Meghnad Das and clearly admitted there is no title deed in the name of Sagar Kumar Das and there is no record in KMC in respect of suit property in the name of Sagar Kumar Das. She mentioned that Fulbasia was the mother of Jogmaya. Dulari is also the daughter of Fulbasia, which means that Fulbasia had two daughters, but there is no document to show that Dulari is the daughter of Fulbasia. So the defendants had nothing to prove how Sagar Das had title over the suit property or how they inherited the property. On the other hand, plaintiff produced original sale deed being 0565014 of 2005. Defendants in the written statement mentioned the deed to be void, but surprisingly enough, they had not made any counterclaim for the cancellation of the deed and thereby for declaration of their title. Deed is of 2005 and till date has not been declared as void for any court of law, which stands good till date. There is presumption that a registered document is validly executed. A registered document, therefore, prima facie would be valid in law. Onus of proof thus would be on the person who releases evidence to rebut the presumption. My lord, the mistake here is that the deed which is sought to be placed as being the cornerstone of evidence on the plaintiff's side, that has never formed the basis of the plaintiff's suit against the defendants. The plaintiff's suit on the defendants is based on the fact that he is trying to show that the defendants are not in any way related to the Jogmaya Devi, who was Fulbasia Devi, who is the owner of the property as admitted by both parties. What a deed recites in the recital cannot be taken as a conclusive proof. It is only a tracing out of title. It cannot be taken to be conclusive proof of title. Bare deed, recital deed cannot show title. My lord, I'm going on. In this case, the defendants have failed to rebut the presumption regarding registered deed. Accordingly, this court has no hesitation to hold that the title deed of the plaintiff till date holds good. Admittedly, the defendants are in possession of the Schedule B property. Now, the property can be possessed by the person in the following status: being the owner, being the lessee, being the licensor, or as a trespasser. It is not the claim of defendant that they have perfected their title by adverse possession against the plaintiff. On contrary, they claim themselves to be the owner of the suit property by inheritance, but failed to substantiate their claim. the substantiation of the claim which is being required here. I am already in possession of a decree which is held by title in respect of the, which is held in respect of the title. When that is completely given a go by the trial court, it is saying that that decree has no validity at all. That cannot be the case, my lord. When there is a decree which is held by title in respect of a property, that decree is, unless overturned in appeal, stands to my title in respect to the property. I should not have to further substantiate beyond what I have already given by way of evidence in another suit in this regard. It is not the case of either party that the property is being possessed by the plaintiff as a lessee or a licensee, and accordingly I am not going to discuss the same. Now, the trespasser is one who enters and remains on the real property of another wrongfully or without the owners or possessor's authority or consent. It also implies the person who intentionally and knowingly entered the private property of another person. Considering the above discussion, I think that when the title deed of the plaintiff stands good and there is no counterclaim by the defendant in respect of the protection of possession, and when they fail to prove the title over the suit property by inheritance or any other way, then the defendants are nothing but rank trespasser over the suit property. This chain of logic is flawed. The learned trial judge holds that I have failed to show anything to show my title, provide anything to show my title, and therefore I am a rank trespasser. This completely ignores a previous decree which has been obtained by me, which holds positively to my title. That is the ultimate mistake made by the trial court in this suit, which is why this finding was overturned in appeal. My lord, I'm not going to bother with the rest. Therefore, the learned trial judge goes to decree on contest in part and gets it and provides a decree for eviction. My lord kindly takes up the judgment and decree passed in the title appeal 5 of 2020, which starts from page 5. The relevant part judgment starts on page 6. Court delivered the following judgment. Present appeal was directed against judgment or decree of the learned civil judge, senior division, second court of Alipur, made in title suit number 20 of 2017, and was at the instance of the defendants of that suit. Learned trial judge thereby decreed the plaintiff's suit for eviction of the defendants from the B schedule property to the plaintiff. He observed that the defendants had no title in this B schedule property and passed a decree of eviction. Being aggrieved and dissatisfied with the said judgment and decree, the present appeal is filed by the defendants. Present appeal is decided on the following points for determination in terms of Order 41, Rule 31A of the Code of Civil Procedure. Whether the learned trial judge correctly held that the defendants having no title are liable to be evicted from the suit property. Decision with reasons. Learned trial judge rightly observed that since appeal is the continuation of the suit and an appeal is pending in respect of the judgment and decree of title suit number 17 of 2009, no conclusion can be arrived therefrom. The learned judge rightly did not rely on the judgment and decree of title suit number 8 of 2005, since appeal is pending against it. However, as counterclaim was dismissed without going into the merit, he correctly held that it was immaterial whether any cross appeal is filed or not, or filed against it or not, it should read. A sale deed exhibit number 2, sale deed by Ananda Mohan Das in favor of the present plaintiffs, was placed before the trial judge. Learned trial court held that the vendor had traced his title, stating that Anwar Jan Bibi was the owner of 5x2 Rifle Range Road, and she sold it to Jogmaya Dasi and Fulbasia Dasi by deed number 1458 of 1938. Jogmaya inherited Fulbasia's estate after her death. Anand Mohan was the only legal heir of Jogmaya. The learned trial judge found that the defendants admitted the ownership of Jogmaya Dasi and Fulbasia Dasi, however denied their inheritance by Anand Mohan. though they claimed ownership by way of inheritance but failed to establish and assert the chain of inheritance. He found that the DW1, though claimed inheritance from Sagar Das, but failed to say and prove any title deed in his favor. He held that the defendants, though stated but failed to prove that Dulari was also the daughter of Fulbasia. The claim of Sagar Das, as alleged by the defendants, failed. Trial court found that the DW1 also admitted that the plaintiff had been taking rent from other tenants of the suit property. Though it appears that the learned trial judge relied upon the recital of exhibit number 2, a sale deed by Ananda Mohan Das in favor of the present plaintiffs, but recital in a deed is nothing but the statement of a vendor which binds him and his successor in interest, but not to others. In addition thereto, it may be mentioned that mere recital in the deed as to claim of chain of title does not prove the chain itself. This is precisely what I had stated earlier. The learned trial judge also found that the defendants admitted the ownership of Jogmaya Dasi and Fulbasia Dasi, however denied their inheritance by Anand Mohan. It is well settled that admission can neither create nor extinguish any title. The learned court below found that though the defendant claimed ownership by inheritance, but it failed to establish and assert the chain of inheritance. Learned court below held that DW though claimed inheritance from Sagar Das, but failed to say and prove any title deed in his favor. And he also found that the defendants, though stated but failed to prove that Dulari was also the daughter of Fulbasia. So the claim of Sagar Das as alleged by the defendants failed. At this juncture, I would like to lay emphasis on the records of the title appeal number 205 of 2010 between the self-same parties of this appeal being directed against the judgment and decree of title suit number 17 of 2009 of the civil judge, senior division, 4th court at Alipur, of a suit for declaration and permanent injunction against the present appellants and defendants in respect of the same property. In that suit, the plaintiff judgment and decree of TS number 24 of 1997 in the civil judge, junior division, 2nd court in Alipur were admitted in evidence. It reveals that in TS number 24 of 1997 of the civil judge, junior division, 2nd court, the present defendants appellants instituted a suit against Debashish Ghosh and others, where Ananda Mohan and along with others were pleaded as pro forma defendants. The effect of decree in presence of a pro forma defendant is to be discussed at a subsequent later part of this judgment. But in that suit, while searching out title of the persons in the suit property, the learned civil judge held that Fulbasia and Jogmaya were the recorded assessees of the suit property. She further found that the plaintiffs Tarak, Mampi and Bulbuli claimed as co-owners of the suit property being inherited from Meghnad, who is one of the legal heir of Sagar, the only son of Jogmaya. The learned judge further observed therein that on perusal of the evidence on record, as well as absence of any challenge, there was no reason to reject the prayer of the plaintiffs. I'll pause here for a moment. This is a positive finding of title by a court, never challenged before any other court, where title was found established from Sagar Das to from Jogmaya to Sagar Das to Meghnad Das to the present defendants. A clear chain of title was found in a suit filed where the predecessor in interest of the current present appellant was a party. The argument that they have framed, that they have made, is that as a pro forma defendant, he did not have any substantial claim against him. Therefore, finding against, he did not need to challenge that decree. As per the CPC, there is no such thing as a pro forma defendant at all. It is as defendant. And when there is a finding of title, and the defendant was at the predecessor in interest of the appellant was party to that suit, if he found that the title has been found in favor of the current defendants, he ought to have challenged that. That is a conclusive finding. The finding that these people have title in the premises is a conclusive finding. It never been challenged anywhere, never been disturbed anywhere. It cannot just be given the go by. A decree of court cannot be ignored by a subsequent court. It has to be taken in its proper light. yes, there have been arguments made that it is a, again, first of all, it's against a pro forma defendant, and that is it's in a suit for injunction but not of declaration. But when the issue is in question, when a finding has been made, that has to be respected. Going on, the effect of a decree in presence of I'll go to those that TS number 24 of 1987 was a suit for injunction, but there was clear pleadings about the title of the plaintiffs therein. In order to find out the binding force of a judgment about title in suit for permanent injunction, Honorable Apex Court in Anathula Sudhakar versus P. Bucci Reddy, 2008 4 SCC 594 held. But a finding on title cannot be recorded in a suit for injunction unless there are necessary pleadings and appropriate issue regarding title. Honorable Court further held, where there are necessary pleadings regarding title and appropriate issue relating to title on which the parties lead evidence. If the matter involved is simple and straightforward, the court may decide upon the issue regarding title even in a suit for injunction. Prior to that, in Sulochana Amma versus Narayanan Nair, 1994 AIR SC 152, the Honorable Supreme Court ruled it is settled law that in a suit for an injunction, when it is issued for the purpose of granting injunction, the issue directly and substantially arises in that suit between the parties. When the same issue is put on an issue in a later suit based on title between the same parties or their privies in a subsequent suit, decree in the injunction suit equally operates as res judicata. In Sajjada Nashin Syed Muhammad versus Musa Dadabhai Umar 2003 SCC 350, court held, where title to property is the basis of the right of possession. A decision on the question of possession is res judicata on the question of title to the extent that adjudication of title was essential to the judgment. But where the question of right to possession was the only issue actually or necessarily involved, judgment is not conclusive on the question of ownership of or title. From the copy of plaint of TS number 24 of 97, it is evident that the defendants number 1 to 3 claimed title through Sagar Das. The court also held the plaintiffs Tarak Mampi and Bulbuli claimed as co-owners of the suit property being inherited from Meghnad, and on perusal of evidence on record, as well as in absence of any challenge, there was no reason to reject the prayer of the plaintiff. Thus, the decision on the question of possession is res judicata on the question of title to the extent that adjudication of title was essential to the judgment of TS number 24 of 97. True, the decree of injunction was passed against the defendant number 1, but Ananda Mohan was one of the pro-defendant to that suit, and that suit was decided in his presence. The word pro forma defendant has not defined anywhere in the Code of Civil Procedure. On the other hand, Order 1, Rule 3 runs as follows. All persons may be joined as this one suit as defendants, where any right to relief in respect of or arising out of the same act or transaction or series of acts or transactions is alleged to exist against such persons, whether jointly, severally, or in the alternative. And if separate suits were brought against such persons, any common question of law or fact would arise. In TS number 2 of 24 of 1997, Ananda Mohan was party to the suit, and the plaintiffs therein, the present defendants, claimed themselves as co-owners of the said property along with the defendant Ananda Mohan. In that suit, a right to relief in respect to the plaintiff's title in the suit property was definitely alleged to have been existed against Ananda Mohan if he denied or insisted to deny their title therein. Not only that, as separate suits, being this suit and the suit TS number 24 of 1987, were brought by or against Ananda Mohan or his successor or in interest, or by or against the present defendants, such common question of fact arose as to whether present defendant respondents had right as co-owners in the suit property or not. Moreover, in terms of Order 7, Rule 5 CPC, Ananda Mohan's interest as co-owner in the said property was shown in the plaint of TS number 24 of 1997, and he was liable to answer if the plaintiffs in that suit were not owners in the property, suit property therein. Geeta Ram Khalasi versus Prithvi Singh, AIR 1956, Punjab and Haryana. A question arose before the Honorable Special Bench as to whether a person who is merely a formal party to an action and against whom no relief is claimed is bound by or entitled to the benefits of the rules of res judicata. Court considers several decisions and it laid emphasis on the observation of a division bench where it was held. If the pro forma defendant in property to a suit, he has every right to be heard, and it would follow that if he refrains from putting his case before the court, he does so at his own risk, and he cannot afterward complain if his rights in connection with the subject matter of the suit are placed in jeopardy by reason of his neglect. The court also considered the observation if a pro forma defendant considers that his interests with reference to the subject matters of the suit have been prejudiced, an appeal filed by him would be competent. Honorable Special Bench accordingly answered the question in assertive form. In this regard, I would further like to add that according to explanation 4 of section 11 of the Code of Civil Procedure, the denial of title of the present defendant respondents in the suit property might and ought to have been made ground of defense by Ananda Mohan in such former suit, being TS number 24 of 1987, by this learned civil judge, Junior Division, Second Court. And as such, shall be deemed to have been a matter directly and substantially in issue in such suit, and that question cannot be reopened at this stage. Appellants once decided had title in the suit property cannot be held trespasser therein. Thus, the observations of the learned trial judge in this regard is reversed and set aside. Though after a clear observation of res judicata on the point of title of the parties in the suit property, no trial can be conducted to reopen the question of title, and the purpose of determination of the question if Jogamaya had died unmarried is nothing but to ascertain the title of the person in the suit property. Thus, admission of the death certificate of Jogamaya as piece of additional evidence of the appellate is not only meaningless but also prohibited by law. More so, it does not appear from the NCR that the appellants ever tried to call for the municipal record in order to prove that Jogamaya died unmarried when they were leading their evidence. Document was also obtained in the year 2005, that is long before the institution of the suit. Appellants did not take any steps to produce duplicate copy of Jogmaya's death certificate. It is not their plea that they did not know the fact that Jogamaya died unmarried. Thus, exercise of due diligence by the respondents, such evidence could not be produced at the time of production of this evidence, therefore rejected. Be that as it may, in spite of the rejection of the appellant application under 41 Rule 27 of the Code of Civil Procedure, aggregate, the appeal succeeds. Thus, the appeal is allowed, and the same is allowed is contest against the respondents. Judgment of decree of title suit number 20 of 2017 of Civil Judge Senior Division, Second Court of Alipur, made in suit property from the defendant, as passed by the child judge, is hereby reversed and set aside. Suit filed by the respondent plaintiffs are dismissed, no discourse. Now, my lord, the point herein made is that the adjudication that the defendants in the suit below in the trial court were trespassers were made, was that adjudication was made completely ignoring an earlier judgment which clearly holds the title to the property in a suit where the predecessor in interest of the appellants was party. The mere framing of the predecessor of in interest of the defendant of the plaintiff being pro forma defendant in that suit does not mean that the predecessor in interest of the plaintiff could not have taken objection to the finding of title. He could have put in as objection that these people are not entitled to any decree, being not owners of the land. He could have put in an appeal against such finding of title, but he did not do so. He did not at any point of time make any contest to this finding of title of the suit instituted in 1997. In 2017, how could his successor in interest bring up those same challenges? When his predecessor in interest failed to make any challenge to the finding of title, it was completely barred for the appellant in the second appeal here, who is the successor in interest, to raise those same challenges. The appellant having bought the premises from Ananda Mohan does not get in a better position than what his predecessor in interest has. He merely steps into the shoes of his predecessor in interest in respect of the property. If his predecessor in interest failed to take any steps, failed to protect his interest in respect of the property, to protect his right title interest in respect of the property, that would bind the present appellant as well. My lord, in this regard, one has to look at the totality of facts. It cannot be that you ignore an entire aspect of the case and focus on merely what is been given in the title deed produced in evidence. A title deed, yes, the recitals have traced out the chain of inheritance. But again, as I said, that is operates as against those who have executed that title deed. That does not bind the world at large. It is not a finding of title. That chain of title has to be independently proved. It cannot be taken as conclusive evidence that this is the only chain of inheritance that has been there in the case or can ever be in the case. My lord, here lordship has to take into account the title suit number 24 of 1997. That plaint is in the paper book before your lordship from page 32. Has lordship got it? On 32. The plaint substantially starts from page 33. Suit for permanent injunction valued at 100. Plaintiffs above named states as follows: that one Jogmaya Dasi and Fulbasia
Need
was.
not place the entire plaint.
My lord, I'm not placing. I'm just stating where the title has been traced. Were the owners of 3 katas of land, more or less, being premises number 5/2 Rifle Range Road, PS Koraya, Calcutta 19, more fully described in the schedule below, hereafter called and referred as suit property. That Jogmaya Dasi died before the passing of Hindu Succession Act, leaving behind her only son Sagar Das. That Sagar Das died, leaving behind a son Meghnad Das, since deceased, a daughter of Vishnu Das, and a widow Sona Rani Das, pro forma defendant numbers 3 and 4. That Meghnad Das died, leaving behind him a son, namely Tarak Das, plaintiff number 1, a daughter, namely Mampi Das, plaintiff number 2, and a widow, namely Bulbuli Das, plaintiff number 3. That Fulbasia Dasi died, leaving behind her only daughter Ruma Das, who subsequently died, leaving her only son Ananda Mohan, pro-defendant number 2. That the plaintiffs and the pro-defendant number 2 and 4 thus became sole and absolute and 16 annas owners of the suit property. The heir of Fulbasia Dasi, namely Anand Mohan, pro forma defendant number 2, does not reside in the suit premises. He is present in whatever. My lord, so that a clear trace of title has been made in the plaint. This is substantially the ground on which the plaintiff seeks the decree of injunction in this matter. I will go on to the rest of the plaint as in brief into the rest of the plaint as well. But essentially, the case is that I am the part owner of this property. That one Debashish Ghosh, who has been appointed by by Ananda Mohan, that one Debashish Ghosh has no right in possession of the property. He is a promoter. He is seeking to dispossess me, and thus I am at the situation where I will lose out my valuable property right. Thus, kindly restrain him by way of injunction. This finding of title is essential for me to get this injunction. Because if I was not entitled to the property, if I did not have any right or title in respect to the property, I would never be entitled to such injunction. Because how can a ranked trespasser prevent a promoter or developer or contractor from taking steps in respect of the property. This finding of title is essential to the determining adjudication of this suit. That the defendant number one has no right manner of right title, interest, and possession of the suit property. Defendant number one is merely a building contractor come developer. Said defendant number one had it on intention to construct a multi-storied building upon the suit premises, and with that end in view, he has been hatching plans to evict the plaintiffs from the suit premises. Said defendant number one is a very rich and influential person in the locality, has made collusion and conspiracy with some interested persons for taking forceful possession of the property. Plaintiff number three is a helpless widow and has been passing her days with the two minor children with stringent financial difficulties and great economic hardship. Rent collected from the tenants in the suit property are only source of income from the suit premises. But again, I am collecting rent from the other tenants. This fact has never been disputed by the predecessor in interest of the present appellants or by the appellants herein. In fact, they have alleged the same even in their suit, that we are collecting rents. Point, my lord, is how could I have collected rents from other tenants if I had no manner of right, title, interest in respect of the property? And the injunction that I'm seeking against the defendant number one, how could I be entitled to such an injunction if I had no manner of right, title, interest in respect to the property as the trial court has held? If I was a ranked trespasser as held by the trial court, could I have been granted such injunction? Could I have? That is substantially an issue in this suit. Predecessor of interest of the appellant was party to this suit. He could have at any point of time said, no, you are not entitled to this injunction. You are merely a trespasser, as his successor interest has alleged. You are merely a trespasser. You have no right in respect to the suit. You are not entitled to such an injunction. He could have done so. He never did. CPC nowhere concerns itself with pro forma defendant. That is not a term recognized in CPC. A defendant is a defendant. Defendant can put forward his case. Any finding in respect of title will bind all the parties to the suit, including supposed pro forma defendant. Moreover, kindly see this reading. It's in page 35, paragraph 12. Page 35, paragraph 12. That the plaintiffs requested the other owners, namely the pro-defendants numbers 2 to 4, to join in the suit as plaintiffs, but they having not agreed, they have been impleaded as pro forma defendants. Plaintiffs therefore pray, I'm going down, I'm skipping the other part, for a decree of permanent injunction, restraining the defendant number one from making forcible possession of the suit property and from disturbing the peaceful possession of the plaintiffs in the suit property, for a decree for all costs of the suit, for a decree of any other relief or release to which the plaintiffs are entitled under the law and equity. The judgment and decree in this matter is found at page 38. If I may. নথিটি আদেশের জন্য গ্রহণ করা হইল মামলাটি চিরস্থায়ী নিষেধাজ্ঞা বাবদ করা হয়েছে. My Bengali reading is extremely poor. I take some time, especially প্রিন্টটা পড়াটা একটু মুশকিল আছে. বাবদ করা হয়েছে. মামলার মূল হইল Bengali. Yes, ma'am. From the reading, it does not reflect so. I am having this print is giving me trouble. This is that is.
No, my lord, your pronunciation also like same, not like us Bengali needs.
Well, not. ওটাও খারাপ নয়।
This is much better. If you get the volume copy, certified copy of deed,
Or
then
holographic will,
yes,
he will leave the matter.
it's a bit difficult. Yes.
দাঁড়াও। এই মামলার বাদীর বক্তব্য হইল যে নালিশি সম্পত্তি যোগমায়া দাসী ও ফুলবাসিয়ার ঘোষ
The main portion be placed.
যৌথ
The
সম্পত্তি ছিল।
relevant portion be placed.
Yes, my lord, I'll place the relevant portion.
Relieving of the text.
I was thinking,
Point is very simple. In a suit for injunction, if there is no title dispute, simplicity injunction gone. If the issue of title is akin to the injunction application, then that is holding by a court. And if that is held by a court, then the successor cannot say no, it does not. This is only, that's why we have to place the 2 or 3 plain before my lord and the issue there. That's all. Or any
But-
query from my lord.
this is an appropriate case to be taken up in second appeal. Only involves question of law,
Substantial question of.
substantial question of law.
And point is boiled down to this. Looking to the plains,
Yes, to that the facts are to be placed.
no issue. Subject to correction, my lord, if my lord is
No.
otherwise.
No, no.
Issue. In a simpliciter injunction case, title may not be an issue. My lord has ample experience in trial court below. May not be an issue. If it is not an issue, no problem. It cannot be res judicata. So far as title is concerned. If this become an issue, even my lord not in direct hearing, then my lord this become a res judicata. Apex court has said, your lordship court also decided. That we have to substantiate before my lord. Give me Monday, I will
Monday.
not take much time. This is the point only. These are all, my lord, to reach that conclusion, whether there was a issue in the injunction suit. And the parties who are now plaintiff, they were parties there, or their predecessor was party. If that I can prove, then just judgment of the appeal court will hold it.
That is the moot point. The two substantial questions of law which have been framed, that is the moot point.
Only point I should say. Other are but incidental. If I can succeed on that, incidental will not come. Even if I don't succeed in the main point, incidental will not help me.
If the bench is available on Monday,
I will on the Monday.
on Monday, the first.
Yes,
matter.
yes, no problem. If prior notice, no problem. If the meantime is taken up, my lord, it is difficult to move from that.
The counsel is presenting the. No. The learned counsel is presenting respondents. Commences with submission. Commences with submission. But does not conclude. Full stop. Let the matter appear in the next date.
I again tendering my appeal. Should not have taken my lord the brief like this.
No.
Because they are unable to follow the argument of the appellant. They have taken the no objection brief.
Have you furnished the written notes?
At present, my lord, I have
I've
no
asked
plan.
Had he been with him, he could have provided me.
Mr.
That is-
Ghoshal is not available.
Today is not having.
Is he well?
Is well.
He is well. But if I ask him, how are you? This is the problem. If I say that, no problem, don't say this. You did not treat us for your senior advocate. Get to do. Monday morning I will.
If subject to the availability of the bench.
Up till now, this creates problem. My lord has ample experience this side. If I make myself ready and the court does not take up after 2-3 days, on the court.
I can stay. What's happening? I have closed my argument already. Well, I didn't do here. You're supposed to come.
No, it was,
Just for a short recollection.
let he be present. Be
No,
kind
just
enough
here
to-
in the, I met him in the corridor.
Be kind enough to intimate him through somebody.
Lordship. এই দেখো সামনে। Okay. Six. I'll go with that part. Thank you. Sure.
Extremely sorry.
No.
Uh,
It will be taken up on Monday.
Monday is very. Right now, I've become handicapped. My clerk has been admitted to the hospital. Just now, through the medical unit, I have admitted him. Instead of Monday, my lord, I'm in too much difficulty, my lord. I am most humbly praying.
Let
My
there
lord.
be somebody to.
I will be. I will try to be present.
Okay.
Grateful, man.
Come on, and finish here.
Have you furnished written notes?
Lordship?
Have you furnished written notes?
No, I have not. I will. The Lordship was expressing that. That is the correct point.
We have heard that. But in this matter, trial court passed degree against us. We are the defendant. Suit for recovery of possession under West Bengal Premises Tenancy Act. Suit for ejectment.
1956 or 1997?
No, 1997.
1997.
And my lord, and appeal court reversed the decree. As you know.
Under 1997.
1997.
Decreed by the trial court.
Decreed by the trial court.
On the ground of
reasonable requirement and notice is valid.
reversed by the first appellate court.
First appellate court.
On what ground?
On the ground that my lord, notice is bad and inoperative.
In this matter?
No, madam. Mine item is 9. I don't think it will be reached today.
We are going on 6.
6. Because
There's
he's going
resolution
to take
today.
almost half an hour.
But,
There's
at least
resolution.
2020.
There's resolution today.
Yes, 3:30.
So I think
not.
So release from
not all.
9.
You-
Madam, I
can.
will be going to 30. 3 p.m. fix 30.
Let there be somebody.
My lord, only difficulty, my lord, I understand on Monday your lordship is sitting.
Maybe.
Maybe. My lord,
Because
in all
I
likelihood-
myself even don't know at this present
Yes, my lord,
juncture.
that I am absolutely aware of. My lord, in case your lordship is sitting on Monday, my lord, an accommodation might be paid on our behalf because I am not there on Monday. So, and I think Tuesday, my lord, your lordship will also not be. Because of the vote.
What did we say now?
Much obliged. My lord, I take your lordship.
So the moot point is notice.
My lord, main point is notice.
Hmm.
Notice the main point, and another point is whether the plaintiff at all entitled to file this suit, because the deed of conveyance, this is a trust property. They registered the deed of conveyance, but there is no permission from the district judge. They have referred that there is a permission of the district judge, but no such exhibit is there. Only mere stating in the deed of conveyance.
Learned counsel, one question or one point was raised from this end.
Lordship. I will give you a reply. Let me please submit.
I mean, Lord, mere typing in the registered deed that there is a permission, but which has not.
They couldn't show that there's a permission.
Yes,
from the
yes.
district judge.
No exhibit. So that is the my ground, threefold ground of us. That is the suit is not maintainable on that ground because the deed of sale is absolutely void in absence of that documents. The permission given by the district judge. First thing. Second thing is, my lord, the notice to quit has been served on us within the year after purchase. It should be.
Statutory limit has not been.
However, suit has been filed afterwards, but the notice is the part and parcel of the suit. Notice to me is the initiation of the suit, and that should be after 1 year. This is our contention. And third thing is this: without reasonable requirement. Reasonable requirement without commission cannot be proved.
To prove reasonable requirement, commission work should be there, must be there. But in this case, admittedly, there is no commission work. 3 points.
The first point is the notice.
Notice.
The second point is permission from the
district judge. That has not been admittedly exhibited.
And the third
point is without commission work, reasonable requirement cannot be proved. And it is the plaintiff's baby to feed on. If we make silent, but it is the plaintiff's duty, burden on the plaintiff to prove through commissioner.
What are the substantial questions of law framed?
Substantial question of law is, my lord,
only one substantial question of law. Oh, having issued within 1 year from the date of acquisition of title by the landlady appellant in view of the embargo created under Section 6, subsection 2 of the said Act. That is the first point which you have raised.
Yes, Miller.
Apart from that, as regards to the permission from the district judge and reasonable requirement, there is no.
No, but I think, Miller, we have to file one application to bring this point before your lordships. Otherwise, thing is this, however, this is also point of law. In the second appeal, there is a chance. However, there is a limited chance to raise the point of fact and also the point of law. Because, Miller, the notice is the point of fact and point of law both. And reasonable requirement also, I can say, this is also there is a point of law. Because whether the commission work can be, whether without commission work, reasonable requirement can be proved. This is also vital. My lord, two things are really vital. And my lord, at the time of hearing, if your lordship feels, your lordship can take this matter on judicial notice also. Rather, my lord, I have to file one application to bring this. My lord.
As regards to permission from the district judge, that is not a substantial question of law.
But my lord, if the suit is not maintainable, kindly appreciate, if the deed is invalid, then suit is not maintainable.
That is another aspect, but that is not a substantial question of law to be framed for hearing second appeal. And as regards to the other point, that is whether commission is
yes, my lord, this is a vital point.
That is also not a substantial question of law to be framed for hearing second appeal.
But
that's why, keeping in mind these aspects, the honorable division bench has not framed those two questions.
But my lord, this is the sine qua non. Your lordship knows very well the commission work should be there, rather must be there to prove reasonable requirement. Otherwise, how could it prove? So, my lord, I kindly
that cannot be made a substantial question of law.
But this is a point of law, my lord. Mixed point of law and fact, my lord. That can be said. This is a mixed point of law and fact, my lord. And my lord, I have got the judgment afterwards when I.
The counsel, what do you have to say as regards to?
Lord, my lord is arguing by vital points. I, due respect to his vitality, he has not filed any appeal.
He has not filed any appeal.
That answers the whole thing, clinches the issue. No. Now he is stopped from pleading these things, which is not there. It is my appeal. My learned friend is arguing like appellant. And secondly, it is too late in the day to file an appeal also. And it is unheard of procedure for filing an application for bringing point of law by the respondent. When the second appeal has been admitted, only one point of law.
If the division bench has not framed any substantial question of law, during the course of hearing, it deems to the hearing judge, learned single judge, that a substantial question of law, further substantial question of law is to be framed, he can frame it.
But I will bear this question in mind and I will cover this point in my written argument.
Yes.
I will bear this in mind.
That can be dealt with. But once again, I am saying those two cannot be implemented as substantial questions.
The mode of proof.
But those two are to be dealt with by both of you.
Those are mode of proof.
Yes.
whether the requirement was approved,
Keeping in
etc.
mind, the Honorable Division Bench has not framed those questions as substantial questions of law.
But as you will also observe that during pendency, during hearing, if your lordships feels, your lordship may.
Yes.
That I can
So
say.
I will be obliged to address this question.
That is known to everybody. But that will not be a substantial question of law, but both of you will have to deal with those.
As your lordship.
I will oblige to address this question.
Yes, Lord Counsel.
Now, my lord, may I place the plaint? That the premises number 13C, Rajendra Lal Street, being a two-storied old building with staircase lying on the eastern back portion of comprising originally belonged to the Devattar estate owned by the Sebayat Samol Kumar De, Amol Kumar De and Bimal Kumar De. And the owner Sebayat has been Sebayat typographical possessing and enjoying the
Plain. Need not place the entire.
Okay.
The relevant portion.
manual time is a very hard to understand. And now this is offshoot of 2006.
Trial court at the first after orders there will be the plaint in the trial court record. টিএস তো এটা টিএসটা তো
owner Sebayat Ablat before the learned district judge at Alipur court for permission to sell the premises to the to intending purchaser, stating therein that a premises is worn out and dilapidated. The owner Sebayat prepared to maintain the premises by making through thorough repair and list the income property is meager when the learned district judge of Alipur on hearing the parties granted permission to sell the premises. The intending purchaser, the petitioner of the suit, basis is where is basis on the existing monthly tenant in common. The owner Sebayat being permitted by the learned district judge sold the premises number 13C Rajendra Lal Seth Street on 14/3/2005. This date is very vital for disposal of this suit. By executing a registered, legal and proper sale deed and assigned the arrears rent as the existing tenants are defaulters since November 2000 something, and delivered the symbolic possession of the sold premises with the tenants to the purchaser with assignment arrears of rents being the so. Milord, in this matter, Milord, may I submit, which is I have submitted, that there is a mention even in the sale deed, but there is no such exhibit before the learned court below of that decree or that order or that permission. No such exhibit. It is the admitted position also. Now, in absence of that permission, the entire sale deed is void ab initio. Entire sale deed, however registered, there is no dispute regarding registration, but without any lawful document, which is before the learned court below through an exhibit. Until and unless it is an exhibited, mere writing in the sale deed that cannot be validate that registered sale deed. This is my argument.
Lord Counsel, has that been an issue before the trial court?
Whether suit is maintainable, that issue govern everything. Whether this suit is maintainable or not.
There it has been discussed. Let us go to that point.
Now, my lord, so if in absence of that document, my humble submission is before your lordships that this entire suit is not maintainable because the sale deed, the title deed of the plaintiff is void ab initio. He cannot have the right to file this suit because this is a derivative title, my lord. If there is an original title, we cannot deny, but this is a derivative title. Derivative title can be challenged at any point of time, especially on the point of law, on the point of conveyance, I can. And if it is not derivative, I cannot, because he is not my inducting authority. He has purchased the premises through that deed which is not legal.
Lord Counsel, in which under which issue it has been discussed?
Issue number 3.
Issue number 3.
The owner of the suit property.
Let it be placed.
Case 31 of paper.
Place the issue. Discussion in the issue. The defendant had raised the issue. Issue number 3.
Yes, my lord. Whether plaintiff is the owner of the suit property. Now, my lord, that is 31 from 31. This is the my lord.
Oh. The court, after due consideration on documents in the record held in order number 38, dated 18/11/2010 that plaintiff is due owner of the suit property and have purchased the same after obtaining the permission from the Dhara district judge as it is required in case of Devottor property. Hence, to discuss and again decide the same issue is not necessary.
But my lord, thing is dealt with, my lord. The point is dealt with.
That has been dealt at the time of disposing of the 7-2 application.
But that point has been dealt with. My lord, 7-2 application, kindly 7-2 application depends on the relationship between landlord and tenant. But here the issue is bigger than landlord. Here, if it is the derivative title, my lord,
to come to the just conclusion, let us go to the order passed at the time of disposing of the 7-2 application, dated 18/11/2010.
Is there any in paper book, my lord?
There is a paper book containing only the judgments and the memo of appeal.
There is nothing in the 7-2 order. The order passed in the 7-2 application is a temporary in nature, my lord. Final order is the suit. Kindly appreciate, my lord. Final order is the suit. That is temporary.
It has been mentioned that therein it has been discussed, dealt with.
But in the
order
suit,
number 38 dated 18/11/2010.
but my lord, in the suit, my lord, there is also an issue. Also, that has
specific issue as regards to that permission.
But that apart, my lord, the exhibit should be there at the time of trial, my lord. 7-2 is the before trial, my lord. But until and unless the trial is made, if it is found that suit is not maintainable, then the 7-2 has got no effect at all. If the suit is not maintainable itself, which has been tried at the time of trial, at the time of argument, not at the stage of 7-2. 7-2 is the primary measure, not the final order, not the final verdict.
Place the cross-examination of defendant number 2.
In the paper book, only the orders is there. Cross-examination. The handwritten cross-examination, I think. পড়াই তো যাচ্ছে না। Absolutely illegible, my lord. Cannot.
On from the order dated 18/11/2010, it transpires that it has been mentioned on perusal of Exhibit A. It further appears that in miscellaneous case number 179 of 1999, learned district judge Alipur permitted sale of the suit property. Hence, I am to hold that the plaintiff is the owner of the suit property.
But that document is not before the learned trial court, my lord. But
on perusal of Exhibit A, it further appears.
Yes, Exhibit A, that is the sale deed, my lord. Exhibit is the sale deed. So my contention is this, my lord. Deed of sale is Exhibit 1.
What is Exhibit A?
Exhibit A, that I.
It has been exhibited at the time of hearing of 7-2 application.
Lord, subject to please, that exhibited is in the record before lordship. That exhibit, the exhibit A. I think, my lord, in our paperwork or in our document there is no exhibit A. There may be a, but
Exhibit A is the sale deed. No dispute about that. Deed of conveyance.
অবস্থা খুব খারাপ রেকর্ডের। So the sale deed is void ab initio.
Learned counsels provide cover, file cover, new file cover, both of you, and go through all the documents. It has been mentioned that in miscellaneous case number 179 of 1999 of the learned district judge has permitted.
It is there in the conference.
Alipur has permitted sale of the property.
But there is no such decree, my lord. There is no such order, my lord. That I am referring from the beginning, my lord. There is no such order before your lordships, and which has to be exhibited to validate the sale deed.
Where the fact admitted need not be proved. It is a fundamental tenet of law.
What admitted? I have never admitted.
The order itself.
I have challenged.
They admitted the
No. You should give that document, that decree, there is a vital decree, your lordship.
He admitted I did not give.
No,
Fact,
nobody
admitted need not
admitted.
be proved.
Nobody admitted.
Dispensed with.
Nobody
Record
admitted.
it.
Is there any order that?
Yes, here is an order. Here is the order. Kindly take up the order dated 1811 once more. 1811, 2010.
Need not,
Sorry.
Warden. I'll go through. I was going through and have placed that on perusal of Exhibit 8 further appears that in
A is convinced. A is convinced. It admitted.
179 of 1999, learned district judge Alipur permitted the sale of the property. And on perusal of Exhibit A, it is clear that the plaintiff has purchased the suit property from the then Shebites of the suit property. Moreover, the defendant number 2 has admitted in his cross-examination that the plaintiff has purchased the suit premises from the then Shebites of the Devottar property.
Purchase is admitted. I am not saying that they have not purchased, but where is the decree? Purchase is admitted, no doubt. I mean, I have never challenged the purchase, but whether deed is.
Learned counsel, keep in mind the issue raised by him and deal with that issue.
Lordship. I'll also try to elaborate on the presumptive value of a registered conveyance. What it means. I'll try to assist your lordship.
Go through the documents and be kind enough to furnish a fresh cover file.
Another file there, ফাইলের অবস্থা খারাপ
ঠিক করে রাখবেন বুঝেছেন ঠিক করে রাখবেন দেখবেন ছিঁড়ে না যায় আর খোলা আছে কিন্তু একটু গাইড করে দেবেন কাউকে ডাকে ওই সেকেন্ড অ্যাপিল ডিপার্টমেন্ট
Therefore, my lord, it is admitted position. There is no such decree before your lordships or before the learned trial court. There is a deed, and there is a written over the deed. But mere writing in the deed that does not sufficient proof without that exhibit, without that decree. This is a very vital for this case because it is a derivative title. Para 4, date of conveyance is 14th March 2005. And notice has been issued within a year from the date of purchase. That I am coming. Thereafter, my lord, after purchase, para 5, that on or after purchase being completed with delivery of possession of the sold property, therewith vendors and the purchasers separately issued letter of atonement letter and demand letter to the existing tenants in commons, directing the tenant in common to atone their tenancy and to pay their monthly rent with arrears of the purchaser landlady and for their relationship of landlord and tenant in common were established between the transferee landlord and the existing tenant in common, operation of law and the same binding upon the under the West Bengal Constitution 1997. Now, my lord, regarding 7.2, may I clarify, my lord, the order passed in the 7.2 application is a tentative in nature. If the suit is not there, if the suit fails, then automatically everything fails. Interlocutory order. It is finality reach when the suit is disposed of, then finality reach. Otherwise, interlocutory order, which is the fate, that is the fate. Even at the time of 7-2 application, that order, I think that has not been placed. Because if it is placed, that is before your lordships. That is not placed. Only the deed of conveyance has been placed. Now the point of, now the notice point, my lord, that is para 12 of the plaint.
Yes.
That the petitioner, through her authorized agent and advocate Sri Sudhanshu Shekhar Basu, determined the tenants in common by an ejectment notice under section 6(4) of the WBT Act 19 dated 25th 11 2005. 25th 11 2005. Milord, date of notice is 2011 2005. Milord, 25th 11 25th 11 2005. Therefore, Milord, they purchased the property by sale deed, that is, Milord, 14th March 2005, and notice has been served on 25th November 2005. Within 1 year, Milord.
25th November 2005 and purchased on
14th March 2005.
14th March 2005.
Paragraph 4 of the plaint.
Oh, within 9 months.
Within 9 months.
So according to you, notice falls within the ambit of
section 6(2).
And as such, it is to be presumed that the suit has been initiated within 1 month, within 1 year from the date of purchase.
That has not been done. It is an admitted position. And Milord, it has been stated that by calling upon the opposite parties to quit, vacate, and deliver a vacant peaceful possession of the tenanted premises known as scheduled premises with the expiry of the last day of.
So that point is to be considered whether the issuance of notice
is the initiation of suit or not.
It is,
because the notice is the part and absolutely.
Whether it can be served within 1 year from the date of purchase or not.
Yes.
I am not going into that issue that whether notice is a initiation of the suit or not.
That is separate issue.
That is a separate issue. Whether it can be
served or not.
Served within 1 year or not from the date of purchase.
From the pleadings, it has been served within 1 year.
Correct, counsel. You will have to satisfy this point also. Take note of this point.
And the said notice was separately sent in each member by names by registered post with AD in respect of which was accepted by one brother on 28th November 2005. And the letter containing the notice back undelivered with the postal remark not claimed, and the same tool marks or to valid and legal service notice upon the address. Now, my lord, thing is this: they have served as per their condition. They have sent the notice to all. One notice has been received by one of the parties, that is 28th November 2005. And other notice delivered, undelivered. Remarks this not claimed. Whether that notice is marked and exhibited, Lord, I have to see the exhibit list. Lord. Exhibit list are like notice gulo kabe kabe ফেরত এসেছে My lord, 330 is there, my lord, resolution.
On behalf of the tenant, there is 330.
I do not know. There is a resolution. How hard there is a resolution, but I confirm.
Beloved council representing the representing the respondents commences his submission, but could not conclude due to paucity of time. Here, the next for further
নামটা দিয়ে দিন।
hearing.